addresses the court.
I cannot say so. At any point in time, a new counsel comes in, he thinks that he want to provide further evidence, he has a right to make an application for recall of witnesses or for a call of new witnesses. And he needs to also study the brief and be able to deliver his address to the court. And in all this,
the court drama is still on. Nhyira Chairman Wontumi, the court cases are hold. The latest are ever a Monday, so many issues. Recently, the Mcbrown, more court, not just a lawyer and the appeal could be the application for so person withdraw a free case in. And a court ama a home ruling now, or more. The reason as to why on Bogu any the way forward and all that, and from court or lawyer and the appeal could be kasa extensively in about 20 minutes. With me church and say the way forward and all that. And in this same episode, I'm to me make changes. What I say, reshuffle. The legal representation are almost aiding in court. Now, say lawyer and the appeal could be no and leading in all the cases. And to me statement what dropping say with me lawyer and the appeal could be everywhere. Not what the lawyer for Abba, a lawyer bay, me pato, ye bet me breaking it down at the amount. Meeting Eddie CK, a Phoenix, and our first time I want to subscribe to the channel and say a drop video, I will be update. Now, yes, I say, in June, it's around Thursday or Friday. That was when a lawyer and the appeal could be 80 Ebimiki known. As a person withdraw from Wontumi court case at Ekoswa, which is the Samurai Boy case at court, said by July 3rd. Ye bet me, I'm at the final verdict to know such Wontumi would differ and answer with him or Kofi and answer or them. Now, lawyer no me say there are some issues be a woman who feel says or no chene one a bebwa ama case na ko fairly. Said the essay echo because who feels one case no and the issues be a bread ne client. With me at the motion echo to himself is what chene home. Now, a broad no the attorney general or the state and so it make a counter say omo and as omo call echo catch the court and so also counter the decision to withdraw no say my court need me engine to ampa ene court na transi ese sa eye the motion or appeal or the application and lawyer and the appeal could be the abasa or person watching who if case no me pa cho judge ne what na adwam e wo case so was one jintum ema lawyer and the appeal could be intime nchene ho ono abogu na ye be ko no ati and the appeal could be after say eno eba ye no no achichim the court so e wo court ho na ene was asa issue no eba ne chema Wontumi etimi drop an official statement e wo e ne legal representation or say or person will make changes e wo the lead counsel or make reshuffle e wo ho enti ene statement or the by no enie or say I Bernard entry boss yakon chema Wontumi wish to respectively inform the court, the parties and the general public that I have decided to appoint Honorable Lawyer Samuel Atta as my new lead defense counsel in the ongoing criminal proceedings against me. Into which we decided say Afia or the Akuffo court name say or person lawyer and the appeal could be now names we case in from 2025 on step aside. Now the new one are all Kofano lawyer Atta and everything. What ye video am never just a lawyer appeal could be to make our court on now. It tells you say there is some taxes be air cause because appeal could be chima. The new counsel also take you over no has the right to call new witnesses, examine the case, and even to some extent or try say be a case in Ombesan so I shall no man say did for invite a whole lot and more boy a strategy in the taxes be. Yabako no lawyer no and some more beka. And it feels like they all kind of video no and a manifesto I chama Wontumi say Wontumi appointed lawyer a year attaching. SONO may take over as the new lead defense counsel in the ongoing criminal proceedings against me. This has been taken after careful consultation and in the exercise of my constitutional right to legal representation by counsel of my own choosing. It is intended to ensure that my defense is presented fully, effectively, and in accordance with the law. I express my sincere appreciation to my previous legal team for their services and commitment through these proceedings. My decision should not be construed as a reflection on their competence or dedication, but rather as an exercise of my legal right to determine the composition of my defense team. Also, all Pam Womi and also Oyen such a idea attaching Abana appeal could be a quarter and interest said, it be appeal could be a one homodin, why any day, and will show appreciation. A hand over say, The charges before the court are serious, and I remain firmly committed to defending myself through the due processes of the law. As with every accused person, I am entitled to the presumption of innocence until proven guilty by a competent court of law, and the burden rests on the prosecution to establish every element of the offenses charged beyond reasonable doubt. Accordingly, my newly appointed counsel will take the necessary lawful steps to assume responsibility for my defense, review the record of proceedings, and make all submissions and applications that may be necessary to safeguard my constitutional right to a fair hearing. I have full confidence that the judicial process will be the end of the day. No, a court now bubu and a twaso. So, Chama Wontumi some more the abetuja eno. Ese or the same Appiah could be out attaching in to make sure say obenya the justice are on so it is evident. Young court, a bra lawyer and the Appiah could be free court following the application of the court to watching one court. Etimi ebogu ye no yenkoni yentie lawyer Appiah could be in some of the two that the court so court the next case or the next step our etimi eteki
yeni nyi ho say ye betimi anya kukodo no ne anije ade agina ye client nachi say ye ni lawyer and the entire kasa ni say ye nu say empempi no ruling no bi ho no ekono ya na ye ntiase ya na ya hagini na it's true. They can say submission of no case. A rule no 2 sentences. They say it is dismissed without giving reasons. Yeah, per time I said Mcbrown, Mcbrown go 2 cases. Babe back 2 o'clock. And no, enough time to prepare to defend our clients. Okanswa, court, a man, appeal. Obi beka say, I didn't know what you say. Appeal. Appeal back since 18th of March 2026. I appeal against the decision about submission of no case to answer. Now, see record video say more than 3 months. Say appeal the court to file po register po and the organize records no. Timia transmitted court of appeal. Let's just say appeal process nakasano. Yeah, no, it was our court we know. You lose confidence. Say, yeah, the beer betu already March 3rd. Timikra and certain records. And TSA for Froqua and also a bad day. Anything I ain't me appeals no call send it TN because judge you know would say file no. I could see court ho. I'm a file no to be move and call registry. As I said, yeah, you man a bit me a appeal. It's a can see a appeal. Appeal no, the Erika Quaker, you who so far so. And I could be. And they are, yeah, Attorney General say, file preliminary legal objection. Or file, yes, I can be, yeah, or court, no moment say we a copy. And also, we didn't want, and ye say, the court system, your bailiffs, a bailiffs, best say we are chambers. And your court no attorney into bailiff to serve us. And in near my cost of court to home. And then I may who say, a beer not a personal disposition, and then why a client, ye a work film, I'm a client, a lawyer for obey Babebuano.
Now, Council, now I say, work film argument among for can say, who say, time judgment and every banner up bang. Dodo said the you work from Sevilla into me and walk right over this.
Yes, a time no be Nian wa yehu no emwa fair trial. Enti bia na meminti na nian no eba de saa bia na obi ba na nian na sesa. Se ne bia benya fair trial. In all cases, criminal trial, a fair trial under Article 91 of the Constitution. I see a man of mere. Now we hear information or we hear evidence and the defending him. Obia na ye record time. You who be that case yaba and Mcbrown chambra 2 o'clock, 3 o'clock. Na na and no ye who say Asempa one be easy. There Asempa way see no. And say concern. It be na me from so tina Asempa city. It is under no circumstance. Me say evidence that the whole. And there may be possible outcomes. And in Gracia, any glory. Enti the obi obey decision was our case here that way. Any evidence they will. And they say the Nimbeguasi and that's obey qualified.
Because the court and say any say obey application. The next step here.
Next step say may officially withdraw from the case. I'll file notice of withdrawal. Now may be more case. Now say Ghana ne say I see a tumika near pass judgment on somebody. Court to say procedure no by say inform court to say it is unknown to criminal jurisprudence. I agree. Then so law there maybe I grow. Now in the case of Republic versus Dufo, before that case, there case management criminal trial. But in the case of Dufo, the court ruled say SSA case management. And since then, no, case management, including even in this case. Now, case management, any criminal procedure, maybe, but send a court who say a better fair trial, you import case management from civil jurisdiction into criminal jurisdiction. So, I can say notice of withdrawal of legal services. In fact, recent time, Mrs. Gertrude Tokonu versus Attorney General. Lawyer, court was say, on to me representing the client in the view. Court to say improper and incompetent. Say, Obecho, let's take a now, says, of a Kyea, Ube from court to know a compass by way of motion. And to say, court to know Supreme Court to, I can say, Supreme Court to so can one can say in civil trial. Or say, who back court to a by way of 1 year, as properly by way of a motion. Taking advice from Supreme Court ruling in that matter. If you listen, a better papa see a better court near the motion, a better from court, no, Obra to say, and the Appiah could be only presented. Wontumi bill was a case him. Send me a bear and Koba say, oh, for a chair boko and already. And I said, the TSO only the Appiah could be one presented Wontumi to the end. And into any Supreme Court again, I been one AGB in the case of Dufo and the case management. And it is a court to grow. There, now possible see about adopt to proceedings in civil trial in a criminal matter. Now as a court to do so, now you grow in that direction.
Okay, that's the last one. Finally, to see our court in the ruling about still filing where you work. In Japan, see where you work from. Yeah, I expect to say different counsel. Anyway, the case and I say, what do
oh, yes, I'm here, Manu. Me, my catcher, the entire may be work from. A been a DC is a court to man, a 7 me processing. Yet proper. And my catcher, no. Now, your decision, so by appointing new counsel, and I say, oh, appointed. Say, court to counsel, we file address to say, for whatever it is worth. For whatever it is worth. First, you know, I can't say maybe. And we are also advised by the phrase, for whatever it is worth. Say, court to say, for whatever it is worth. Not just say, you need to say, file address to Pranti, or before for bar, no bed at failure. But let me for one. So, Kobase, Chairman, want to be appointed new council. A new council, a bar, a file, a musso. Now, here said, when young mere, no repair, no who said, man, baby, I could do. Here said, only call witnesses be a call of Dada, and now say, on call further witnesses. Or who can so baby, and what's a back to say, court to him and requirement for evidence to be become. That's also best, and that's a same opinion. It to be in the records.
Yo, cancer patrol and the issue baby I could read. Yana for baby any idiot says a lawyer, a cobassa or chino from man, ruling now was about a year July 10, in Yamaswana.
Oh, I know dear, baby to me, and she said, Judge, the wide genius of a money judgment on July 10. Temaun to me, while Quenya so be follow a bio person or follow a na, and a more lawyer and a person to a Mcbrown, so no be anti me free in some. Or who quite so be two and a mombia Mcbrown so episode 2. Na Yashin, Senia Ebeko.
Oh, okay. And so, baby, I be doing so lawyer no. A person of different a bit of some not what the Aboriginal ruling on one.
Oh, difference in Americans, the chairman won't to me so far lawyer for fra. lawyer no embra kwan so wa kwanya say obeba court na the person de bedom court bia o de bedom court na anamon bia court no so betu afa de de beba no court na tu e de afa ho.
Oh, okay. So the man focus ma pa chama Wontumi nya sanity.
Oh, Dabi.
Moja no quantify.
Dabi. E be den the general quantity. Don't forget say your cases miensa e dey represent Chairman Wontumi. Criminal court one case, still is ongoing. We are still representing Wontumi. For specific reasons, our lawyer and the Appiah Kubi esusu say undermine the representation. This particular case, criminal court 4. Enti na wagina so say or twene ho a free case in enti enche say wagya Wontumi wajeje mu ana say akwantin fi ana say so mfimfi ni wagya na say wanya sanity.
Oh, okay. That's very good.
The court has heard part of the, let's say, the AG's preliminary legal objection, and effectively the court is saying that your application is alien to the court.
That's right.
And it's incompetent, and same has been dismissed. What's your immediate reaction?
Well, law is growing, so we should be patient to learn the law, even in situations of difficulty. But we relate to precedent at all times. And you remember that the civil procedure rules are different from the criminal procedure rules as we operate in the courtroom. But in the case of Republic versus Dufour, it was determined that case management, which was part of civil procedure, be adopted by the court. And since then, we have all adopted case management, which is part of civil procedure. And in law, whatever is excluded should not necessarily be included. But it does not also mean exclusion in another area of law. So once the courts have adopted part of civil procedure, there's a presumption that other parts would be appropriate if invoked. And in a recent case of Mrs. Gertrude Tokonu versus the Attorney General, counsel wrote a piece of letter to inform the court of his withdrawal of services. But the court considered that inappropriate and inadequate, and therefore requested a proper procedural approach. Learning from that, and in the response to counsel then, the court said that this is inappropriate. And the court did not emphasize it is inappropriate in civil situations. It said it is inappropriate to address the court this way. So, learning from that direction, we also believe that as a court of records, we should properly inform the court of the reasons why we are withdrawing our services, and also inform all parties of such reasoning. Indeed, part of the argument of the court was that we did not serve our client, the accused person. And it is demonstrable, even in the court, that notwithstanding our intention to withdraw, we have stayed glued to our client even till today. And even on a day like this, we announce ourselves as representing our client. So the withdrawal of representation would be subsequent to today's action, not before, for generating a reason to inform him before we come to court. And he did not also, even though he was in court, object to our decision to withdraw, given a presumption that he has adequately been informed of our intention to withdraw, and we do so now that notice has been served on him and on all parties and even the public. What remains to be done is for me to file notice of withdrawal pursuant to today's arguments. So the notice of withdrawal gives also the client opportunity to engage another counsel.
I think it is where the judge, in fact, that the court had an issue with you that once you are withdrawing the services of your client, is the one that engaged in, not the court. Obviously, clearly inform your client, and then the client can even inform the court that my lawyers are no more representing.
Well, either way, we come to the same deliverable. Is that not the case? That the legal services have been withdrawn. So whoever provides information, I think it is ethical rather for the lawyer to do that and explain why, for the court to understand the disengagement, rather than for the accused person to come to court and inform the court that my lawyers have withdrawn. I think we wanted to do the better thing for the court to appreciate why, and also to demonstrate our commitment to our client up to now. And the words of the judge say that you have abandoned. Do you see any abandonment in the relationship that I have with my client? The answer is no. I have not abandoned him. But it is for reasons like what happened today that I wanted officially the court to be informed of decisions that we have taken as counsel. So we have not abandoned him. We are with him now. We will stay with him until we file the notice of withdrawal officially. And then he'll be given the opportunity to engage another counsel to come and prosecute the matter. You see, we have a lot of complaints, that is why. And in fact, the complaints are in the affidavit. And because people do not want the affidavit to come out and explaining why we are withdrawing, I'm saying that I am disappointed with the performances in the court. That is why I'm withdrawing. In any case, I filed a notice of appeal against the ruling on the submission of no case in the Court of Appeal, and this was as far back as 18th of March 2026, and up till now today, the registry cannot get hold of the docket to be able to prepare the documents to remit to the Court of Appeal. So we have not been able to even settle records 3 months down the line, and if we expect a goodwill from the bench, is it the way to go? Is this how we operate? 3 months, having filed a notice of appeal, I filed additional grounds of appeal, everything, we're done. We expect that we will settle records. By now, maybe the appeal will have been heard. 3 months, the docket is still in the court. You can't get to the registry for records to be settled. And is this justice or is it an attempt to frustrate the hearing of the appeal? This is one of the reasons why we are also withdrawing. And today, you were in court. You saw what happened. The court is now becoming the bailiff. I was served by an officer of the court sitting a notice of preliminary legal objection. And is this done? Ordinarily, bailiffs are not supposed to even serve parties in the courtroom. We are served outside the court. And indeed, when I have indicated my address, you serve me in the place that I've indicated on record as my address. But this is the court serving me rather than the bailiff serving me. So, all this.
One thing that many have spoken about the timing in which you are intending to withdraw your services.
Yes,
one of the things that happened was the fact that if you disagree with the comment and then the push out the judge,
we have filed the appeal, and the appeal that we have filed, what has happened? The appeal is dead and sleeping because somebody is refusing to release the file for the registry to mobilize the documents for transmission to the Court of Appeal or for us to even settle records.
What is your next step?
My next step is to withdraw officially by notice to the court that I have withdrawn. And if it is the case that the court will not allow him enough time to engage counsel to continue with the prosecution of the matter, I leave it to the public to determine, and to the judge also today.
Evidence is over.
I cannot say so.
The court said
I cannot say so. At any point in time, a new counsel comes in, he thinks that he wants to prefer further evidence. He has a right to make an application for a recall of witnesses or for a call of new witnesses. And he needs to also study the brief and be able to deliver his address to the court. And in all this, why are we rushing him to give him a judgment when we have not exhausted the procedural opportunities?